I don't think that flies given the very extensive court precedents on these issues that lay out what can be done properly and what can't be done.
I actually mostly agree with this one, Spakovsky. There are worse things in the world than discretion. Like, could the cops set up a roadblock on the highway and stop everybody asking for identification? No, they can't. Because in Indianapolis cases, they came close to that. So you're always balancing in criminal procedure your fears of discretion with sometimes the worst alternative is something that intrudes on everybody. Again, this is the precise issue in Hyde versus Lewis, where the court says, look, this is Congress's determination, right? It's a crime if you don't apply for your ID in the first place, but we don't want officials to go around stopping people to make sure they're carrying it on state officials to do that. So that's why I say all these trade-offs between discretion and intrusiveness is supposed to be federal trade-offs. It's not something the states can go ahead on their own, precisely because you can't always have the best of both worlds. You have to make some choices when it comes to employment. I think we agree on the idea that discretion is not the biggest problem here. The Supreme Court hasn't come back with reasonable suspicion since 1975. That's part of the problem. And pinning down the appropriate role of racial factors in reasonable suspicion is not so cut and drawn. Reasonable people can disagree. I certainly don't see the cases as totally agree on that. But certainly there's a lot. Reasonable suspicion is the federal standard for a car stop away from the border. At the border, there's no expectation of privacy, and they can search every car at the border. The feds can, the states can. The feds can search every car coming into the border. But once you're a little bit away from the border, like Orange County or Imperial County, California, then the feds need reasonable suspicion to pull a car over, and reasonable suspicion are these articulable facts. There has to be something about the situation that may be different from all the other cars driving on the highway. It can't just, as that's going to be people driving. So I think we agree on the basic standard. That's plenty of argument implications.
You had mentioned that racial profiling is not going to be standard upon which the Arizona laws are going to check folks they stop. But what exactly are the standards they're going to be used? Because there's newspaper interviews where, journalists would ask, well, to cops in Arizona, what are you going to use? And some cop said, oh, maybe we'll look at the clothes they're wearing. And, I just wonder, in reality, outside of the ivory tower, going through racial profiling, what will the cops do to determine either the folks I'm going to ask for identification?
Well, I don't know the answer to that, but you could get an answer to it by reading some of the cases that have come out on it. Okay, like the Mueller versus Mina decision, which I mentioned from the U.S. Supreme Court. Okay, in that particular case, the search warrant that was being executed on his house was because the police had information that a Mexican gang was using this house. And when they detained this one woman who was there, they became suspicious about her immigration status. So the point is that that case kind of laid out what was acceptable and what was not. And to go back to something the professor said, I think I would agree with this. Look, if the only reason that the police stop somebody is because of their race, it doesn't matter what statute they're enforcing. If the only reason they stop someone is because of their race, that's clearly a violation of the law, and you can't do that. But there are a lot of other indications that police officers use to make a stop. The other case I talked about, the First Circuit, which came out of Rhode Island, in that particular case, a state trooper stopped a van. The van was overloaded. When he started asking for IDs of people, nobody had an ID, including the driver. No one spoke any English. There were other factors that led him to a suspicion that, in fact, what was going on was illegal aliens being transported, and that turned out what it was. But you read that case, and you can see what factors the courts say are okay to consider, and what factors are not. okay to consider. I can't lay those all out for you, but you talk to any border enforcement agent with a lot of experience, and they can quickly tell you what kind of things they're looking for that give them an indication that somebody is engaged in illegal activity.
Professor Hyde, Eugene Montreal. A very naive question. Basically, if a state official in honest belief thinks that federal officials are not enforcing immigration laws as they're supposed to, according to the Constitution, which the state official is also, as I understand, is supposed to uphold, what is the state official supposed to do? And as far as I understand, you mentioned, please correct me if I'm wrong, that in criminal areas they can do so, in civil they cannot. If that's correct, correct me if that's what you said. Yes, and then please explain, based on what do we know for sure, for example, that immigration cases are not criminal. Is it firmly established, or is it just based on on the people not getting a lawyer? Because maybe it's just an exception in immigration cases for illegal aliens that you don't get a lawyer, but it's still a criminal case. Thank you, Professor.
No, it's very firmly established that being out of status is not a federal crime. As I said, the government's gone to the well on this for over 100 years. If it were a federal crime, they'd have to read your Miranda warnings, they'd have to do a lawyer, they'd have to have due process. There's no requirement of due process in deportation hearings. They couldn't do hearsay, they get deported all the time on the basis of hearsay statements. There's a slew of legal requirements about the process of removal of aliens to the United States that are built on the assumption that removal from the United States is not punishment, and it's not criminal punishment. We could write legislation redoing that, and I'll tell you, the American Immigration Foundation and the Immigration Bar would kiss you on both cheeks. They'd be happy to draft that legislation, but it's too late for that. That led me to the conclusion I said, however unwelcome. State officials may concurrently investigate people for federal crimes, but they don't normally have power to investigate the federal civil violation. And, said the Supreme Court, the 2 times it had to look at this problem, immigration is even more special. We really, really don't want state officials to create new immigration crimes or to investigate federal immigration civil violations because all immigration policy at bottom is foreign affairs policy that Congress has power to do for foreign affairs interests of the United States. And as I say, that was not a theoretical problem in the 19th century or early 20th century. And I don't think it's a theoretical problem now. I think it's a foreign affairs problem when a state says, we want to use immigration law to make enemies. I think that's a federal decision. And whether you like it or not, if you don't like it, wait for Tuesday's election. I expect we might get some new enhanced federal immigration enforcement out of the next Congress. It should be a completely different proposition. What the federal government can do in pursuit of undocumented immigration is really quite broad, but again, given that it's not criminal. Given that it's not criminal, they really have a lot of fun. The question earlier, you have to keep three things separate. When can you pull a car over? When can you ask people questions about status? When can you get a status check from the federal government? Those are 3 different things. Okay? Reasonable suspicion is the standard for when can you pull the car over. And that's a long list of factors that includes things like it's heavily loaded, they seem to take evasive action, we know it's a van, and we know that kind of van has been used in heroin smuggling in this area before. Those are the kinds of factors you need. It does not, the courts are getting more suspicious about this. It doesn't include the recent one from the Fifth Circuit. The driver looked at me too much, and the passengers didn't look at me at all. This isn't really correct. But you're supposed to have some kind of factors about pulling the car over. Right? Once you're detaining a person legally, search warrant, something the kind of Mr. Spakovsky is absolutely right. Asking an individual her immigration status is not a separate search. It's not a search or seizure under federal law. In the Mania case to which he referred, the city of Sidney Valley, which you all know and love, had a search warrant for the house where Iris Mania was living. Well, that's a totally different proposition They didn't need reasonable suspicion wasn't an issue in that case. They had better than reasonable suspicion. They had a search warrant. They proved to somebody there was reason to think that somebody was going on in the house, gang activities, I recall. Well, once you're there, asking people their immigration status is not a separate constitutional violation, and the Supreme Court was non-zip on that. Then the third issue is, okay, you've asked them their immigration status, and they've told you whatever they tell you. When can you go to the federal government? And that didn't, so far as I know, didn't become a legal issue until this very case. And it was Judge Bolton who said that the combination of Arizona factors which requires the Arizona cops to go to the federal government for status checks all the time, that went too far. And that, I agree, is a novel holding. I can't believe it else.
For Mr. Von Spakovsky, I just wanted to sort of have you defend one of your key assertions and then respond to Professor Hyde's sort of constitutional argument in chief. So, if this is just the state enforcing federal law, which I think might not even be able to do, why are we looking at all these pages of legislation on the screen? This is legislation, and then that segues into the constitutional argument that the state is legislating in a territory that is the federal government's, it's the Congress's plenary power for various reasons that Professor Hyde has articulated. So, lacking a constitutional argument in chief, in my view, could you at least respond to his in that regard?
Well, again, it goes back to concurrent jurisdiction. I mean, the situation right now the situation before the statute in Arizona, as was a lot of states, was that police officials had the inherent authority, without any state statute, to check on the immigration status of people that they arrest. And all Arizona did, in no way interfering with federal law, was to pass a law saying that all local police officials, it's no longer their discretion whether they'll do it or not. They have to do it if there's a reasonable suspicion about their immigration status. So they're not interfering with federal law. They're not interfering with federal law enforcement. They're simply telling their local law officials that they have to take this particular action. And there's nothing unconstitutional about that at all. And I think Judge Bolton made a basic mistake, particularly, and I hate to repeat myself, particularly they says there's a federal law saying that the feds have to respond to an inquiry from a state or local government. No, they don't have an option. They have to respond. And if the judges say, ooh, this is going to be too much if they get all these calls. Well, how can she reverse this federal statute? She didn't say that federal statute forcing responses was unconstitutional and was a power outside of the power of Congress. She didn't find that provision unconstitutional. She just said, well, it's okay if the federal government doesn't comply with the federal statute that says they have to do this.
Hi, my name is Raquel Rivera. I'm a QL. I presume that you, Mr. Spakovsky, advocate for this policy wherever it's necessary, the Arizona bill. So I would like to ask you, according to a study done in 2007 by the LA Times, 30,000 undocumented immigrants are of Irish descent in New York. Do you advocate for a policy like that where
this has nothing to do with race or ethnicity, okay? And
just for the sheer numbers, there are 30,000.
I think our immigration laws were passed by Congress and they need to be enforced. And they need to be enforced against anyone who is here illegally. I don't care what country they're from or what their race or ethnicity is. If you don't want to enforce, if you don't want to have that policy against people who are here illegally, then fine, change federal law. But my point is that the executive branch does not have the option to simply ignore federal law and not enforce the laws. And don't confuse this with legal immigration. I'm a big supporter of legal immigration. A lot of critics in this area try to confuse the two issues. But the point is, I think if someone is here illegally, they've broken our laws. We are a country that's based on the rule of law. That's what makes us so different from so many other places around the world. And in fact, Look, I'm a son of immigrants. Okay, I'm a first-generation American. My parents came here legally